Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 changes to the ethics rules that govern Texas lawyer advertising. You may have noticed in the recent Texas Bar Journal, these proposed changes were published, and I also wrote about these proposed changes at my blog, 5 Minute Law. So what are the 5 biggest, or at least most interesting changes to me? Well, number 5 is that the rules will now have a definition of advertisement. You might be surprised to learn that there was no definition of advertising in the old rules. Now there is a definition. The definition would have 3 main elements. Number 1 is substantially motivated by pecuniary gain. Number 2 is directed at the public in general. And number 3 is offering or promoting legal services. So that's a pretty reasonable definition. If I could make one change to the definition, I would include a sort of carve out that says information that is primarily educational or informational in nature is not advertising. That's basically what the State Bar already said in one of its interpretive comments about the current rules. I think it would make sense to write that concept into the rules themselves to give lawyers a little more comfort that when you put something out on social media that's educational in nature, even if you're motivated by a desire to get business, which would be pecuniary gain, that it's still not going to be considered advertising. Number 4 is that the proposed changes to the advertising rules would simplify the definition of prohibited false or misleading communications. The current definition of false or misleading communications is not ideal because it's really designed to apply primarily to plaintiffs' personal injury lawyers. So if you're not a plaintiff's personal injury lawyer, sometimes it can be hard to understand how that rule would apply to you. The new definition is a broader, more general definition, and I think that makes a lot more sense. The number 3 change to the Texas advertising rules is one that sort of caught my eye, and I just found it interesting. It would prohibit lawyers from communicating that they can achieve results by violence. I wasn't aware that there was a need for this rule. I'm guessing maybe there have been instances where lawyers suggested this. I don't know. It strikes me as kind of a no-brainer that you can't advertise that you can obtain results by violence. So I don't know that this is really a bad rule, but I kind of wonder whether the rule is really necessary. The number 2 change or proposed change to the Texas ethics rules concerning advertising has to do with a dirty word. That word is specialist. Under the current rules, you're not supposed to use the word specialist unless you are board certified by the Texas Board of Legal Specialization in one of their designated specialties. The problem is that almost all lawyers these days specialize in something, but very few lawyers are board certified. So it strikes me as problematic to have a rule that says lawyers cannot say they are specialists or specialized, even when that statement is true. And what that leads to is that lawyers who care about the rules just substitute a different word. So they just say, for example, I focus my practice on this particular area of law. So I have always thought that this prohibition on this dirty word specialist didn't really make sense. The new rule would remove the express prohibition on using the word specialist. I think this means that you could now call yourself a specialist even if you're not board certified, as long as that statement is truthful and accurate. But don't quote me on that. I think that it remains to be seen whether the new rules would be interpreted that way. Finally, the number one change to the Texas ethics rules that has been proposed is that for the first time, the rules would refer to something the kids call social media. Maybe you've heard of this. So the new rule in particular would have an exemption for resume type information that a lawyer publishes on a social media page. So the most obvious example would be a lawyer profile on LinkedIn, right? Almost every Texas lawyer has a LinkedIn account, and so you've got a LinkedIn profile. The problem with that under the current rules is that if you applied those rules literally, every lawyer who has a LinkedIn profile probably should be filing that LinkedIn profile as advertising with the state bar. But hardly anybody does that. So it would be better to have a rule that makes it clear that you don't have to file your LinkedIn profile, provided that it has the customary kind of typical resume type information that most people have on their profiles. So I think that is a welcome improvement to the rules. I have suggested it would be good to go even a step further and have an express statement that having a profile on social media with the typical kind of information that you see on a LinkedIn profile would not be considered advertising. I think that would be good to give lawyers some comfort that they're not violating the ethics rules by just having a typical LinkedIn profile. So those are the top 5 proposed changes to the Texas ethics rules. If you like this video, please hit the like button or share it with a friend. If you agree or disagree, please leave me a comment, and hey, thanks for watching.